On this video, we will analyze the torts question from the July 2000 California bar exam. I assume that you have read the question, given it some thought before watching the analysis here, but in any event, to make the video complete, I'm going to read the question, then we will go through the analysis together. The question reads as follows, paragraph 1. Dan operates a plant where he makes pottery. To provide a special high-capacity power source to his pottery kilns, Dan recently installed on the electric company's power pole outside of his building an electric transformer that would increase the electrical current entering his plant from the main power line. He did this without the knowledge or consent of the electric company. Dan did not know that the power line on which he installed the transformer also feeds power to the adjacent office building. New paragraph. Peter occupies one of those adjacent office buildings. In the building, he has an extensive computer network that he uses in his business to provide advanced computer services to local commercial enterprises. Peter has been in this business for 10 years. He employs several highly paid computer operators and technicians. New paragraph. Dan's installation of the transformer caused power surges each time his kilns were turned on and off. Soon after Dan had installed the transformer, Peter's computers began to malfunction and eventually were severely damaged by the repeated power surges. As a result, Peter lost a large amount of data stored in his computers. He laid off some employees without pay and shut down his business for 2 weeks while the computers were repaired and while the remaining employees restored the lost data. Next paragraph. During the shutdown, Peter lost considerable income because he was unable to furnish computer services to his customers. Peter and the laid-off employees have filed suit against Dan. You are asked several questions. Number one, now the first question is in 4 parts. The key part of it begins, in an action against Dan, what theories, if any, might Peter assert, and what defenses might Dan raise if Peter seeks to recover the following 4 things? Peter wants to recover the cost of repairing his computers from Dan. Secondly, Peter wants to recover from Dan the cost of restoring the lost data. Third, Peter wants to recover from Dan his lost income. Fourth, Peter wants to recover from Dan the loss of goodwill and other incidental effects of the disruption of his business. Second call of the question. May the laid-off employees recover lost wages and benefits from Dan under any theory? And finally, may Peter recover punitive damages from Dan? So Peter wants to sue for those 4 kinds of losses that I just enumerated. Peter wants to sue for punitive damages, and the laid-off employees want to sue for lost wages and benefits. Let's look at the analysis. Now, the way we're going to analyze this question together. That's why I didn't just put the analysis on the board. I want you to see how one might go about doing the analysis. And what I'm going to do is to go paragraph by paragraph, and for each paragraph I'm going to list on the board the issues which I think that paragraph raises. First paragraph. Dan operated a plant where he makes pottery. Well, that by itself doesn't raise any issues. To provide a special high-capacity power source to his pottery kilns, Dan recently installed on the electric company's power pole outside of his building an electric transformer that would increase the electric current entering his plant from the main power line. So this looks to me like in the paragraph 1 that we may have conversion against the power company, electric company, But we're not going to talk about this because we weren't asked about causes of action against the electric company. Okay, conversion against electric. So don't talk about it. Any other issues? Yes. They tell us that, continuing to read, Dan did this without the knowledge of the consent of the electric company. We got that. Dan did not know that the power line on which he installed the transformer also feeds power to the adjacent buildings. And so the adjacent buildings and the persons in the adjacent buildings are foreseeable plaintiffs. Occupants of the adjacent buildings are foreseeable plaintiffs. Also, when Dan goes up on the power pole and starts acting like a professional electrician, Dan is going to owe a duty to foreseeable plaintiffs. Peter's going to turn out to be one of those foreseeable plaintiffs. So Dan is going to owe a duty to foreseeable plaintiffs, but what's important here is that the duty that Dan will owe is not the ordinary duty of due care. Dan is acting like a professional electrician, going up on the pole and changing the transformer. And if Dan goes up on the pole and acts like a professional electrician, we're going to hold him to the standard of care that one would expect a professional electrician to exercise. Okay, if I start doing surgery on someone, you're going to hold me to surgeon standard. Okay, if I start driving my car, you're going to hold me to the standards of a person who normally drives a car. Even minors, as you know, are held to adult standards when they engage in adult activities. So I think everyone would be comfortable with the idea that when Dan goes up on the power pole, Dan's going to be held to standards which are expected of a professional electrician. So we have here the duty. This is the duty of Dan, the duty of a professional electrician. Second paragraph. Second paragraph. Peter occupies one of those adjacent buildings. So Peter is a foreseeable plaintiff. Next. In the building, he, that is Peter, has an extensive computer network that he uses in his business for providing advanced computer services to local commercial enterprises. So he's got all these computers there. You see damage to the computers coming up. Peter has been in the business for 10 years. Okay, if Peter has been in the business for 10 years, that means that we have a good track record. So when Peter has to close his business for a few weeks, we have good business records to show how much loss of income he has. So we have good records for loss of income. He employs several highly paid computer operators and technicians. Well, these employees, we know they're going to be out of work. So, we're going to ask here, are the wages to these employees? This is a foreseeable injury. Next paragraph. Dan's installation of the transformer caused power surges, so you got causation, caused power surges each time his kiln was turned on and off. Soon after Dan had installed the transformer, Peter's computers began to malfunction and were severely damaged. And so, and as a result, so let's put some of the stuff here. I'm going to put number 3 here. I don't want to use too much space over there. So in our third paragraph, Peter's computers, who have actual causations. Peter's computers were damaged because of these power surges. So they were damaged because of Dan's negligence. So Peter's computers, so actual causation. Several things here. One is that Dan's negligence actually caused damage to the computers. Computer damage. Secondly, it says, as a result, Peter lost large amounts of data. So actual cause, he lost data. Next, he laid off some employees because of this. So he laid off employees because of this, and he was closed for 2 weeks. So we have 2 weeks loss of income. I don't have a place to put that on the board. During the shutdown, Peter lost considerable income. So we have loss of income because he was unable to furnish computer services. And now we have all these lawsuits. So they ask you, number one, in an action against Dan, what theories, if any, might Peter assert, and what defenses? Well, if they're asking you what theories might Peter assert, you must come up with more than one theory, even if you defeat the theories. But you can't just put one theory down when they ask you what theories. And so the theories that he should bring are, let's put them here. And his theories are, of course, Peter will sue Dan for negligence, there's no question about that. You might bring a strict liability action. I'm not saying you will win it. You might bring a trespass to land action. Again, I'm not saying you'll win it. And those are about all the causes of action I can think of. So those are the theories. We start through them one by one. We start with the negligence theory. For negligence, if Peter is suing Dan for negligence, we start with duty. Under duty, there are two things. One is to whom is the duty owed, and the other one is what duty is owed. And so here, to whom is the duty owed? It's owed to foreseeable plaintiffs. And you're going to have to prove that Peter is a foreseeable plaintiff. You do this by showing that a foreseeable plaintiff is anyone who a reasonable person should realize might be injured by what the defendant is doing. You're driving your car, the people nearby on the road who might be injured by what you're doing, those are the foreseeable plaintiffs. And so here Dan is changing the transformer on the pole, and you have to establish that Dan should have realized that Peter is a foreseeable plaintiff. Now, what duty is owed to these foreseeable plaintiffs? Well, you normally owe due care, but in this case, it's going to be the due care that a professional electrician would owe, because Dan is up on the pole doing professional electrician work. So he's the due care of a professional electrician. Next is the breach of the duty of due care. Did Dan breach his duty of due care? You recall there are only 4 ways to breach the duty of due care. One is the negligence per se doctrine. The other is violation of the standards of a profession or skill. The next one is the the balancing test, and finally rezips it. Well, in this case, which ones can we use? We can certainly use violations of the standards of a profession or skill, and you would make the argument here that a professional electrician on the pole would have known where the lines go and would have taken the proper precautions, and Dan is being held to those same standards. Secondly, you might use the balancing test. The balancing test, you recall, weighs the risk created by the defendant's conduct against the justification for the risk. The risk against the justification. Well, the risk created by what Dan is doing is obviously that there will be some kind of electrical surges because he's not a professional electrician. So he creates that risk. What's the justification? Well, Dan doesn't have any justification. This is not the case of a speeding ambulance that can justify creating risk on the road because they're providing such a valuable social function. This is not the case of a risk where it's so expensive to get rid of the risk that you can't do anything about it, so you have to leave the risk there. This is a simple case where Dan is stealing electrical power. So there is no justification. So when you weigh the risk versus justification, you again would find that he has breached his duty of care. Duty, breach, causation. Now when we do the causation, we're going to do causation and damages for each damage that Peter wants to get from Dan. For each damage that Peter wants to get, Peter has to show that what Dan did caused that damage. Dan's negligence caused that damage. So we have to go damage by damage and show the causation and what the damages were. So let's take the first of these. The first of these is Peter wants the cost of repairing his computers. So we're now talking, we're going to take causation and damages. So we'll take the repairing the computers. So the repair of the computers, causation, and the causation needs to be actual and proximate. Well, in the case of the computer repair, they told us that the surges caused the computer. They told us that the surges, sorry, get this here in a minute. So they told us that the surges in the computers were the actual cause of the harm, the surges caused by Dan's negligence were also the proximate cause because there's nothing all that remote about this. The surges go down the line, they injure the computers, and so nothing to terminate Dan's liability. So since Dan's liability has not been terminated, then Dan's conduct is both the actual and proximate cause of the computer damage. The damages that you get must also be not too speculative, and there's a duty to mitigate. So the next two factors here is not too speculative and the duty to mitigate. In this case, there's really nothing speculative about the damage to his computers, and the duty to mitigate, there's nothing he can do except repair them. Secondly, Dan wants the cost of restoring the data. Now, Dan wants the cost of restoring the data. First of all, was the data lost because of Dan's negligence? And certainly, you got the causation again. And the answer is yes, the data was lost. Let me put this in here in a little bit clearer form. In fact, I'm going to move this over to another board so you can see it very clearly. So the next one here is the data loss. So we're going to bring the data loss and put it over here. And so was the data loss caused, we're looking at causation and damages now, causation and damages, and was the computer loss caused by Dan's negligence? I mean, was the loss of data? Well, yes, the loss of data was caused by Dan's negligence. We're told that. The data loss was caused by his negligence. So we have on the actual cause, you can put the but for. On the approximate cause, now approximate cause is a problem here because if you have data on a computer and everybody understands that you can have a cheap computer that you could replace with a few $1,000s, and it could have $1 million worth of data on it. And you destroy the computer and lose the data, and the real loss is in the data. And so here, what Dan did caused a loss of the data that was in Peter's computers. Now, are you going to make Dan pay for that, or is this getting too remote? And the answer is that probably yes, but let me explain. In those cases where the harm which is caused is way out of what was expected, you're driving along the street and you bump into someone by accident, just a little bit by accident, and they happen to be carrying the Mona Lisa with them, and you destroy the Mona Lisa worth, say, $10 million because of this little bit of small accident. So you'd say, well, Jesus, I just had this little accident, now they want $10 million. Well, the plaintiffs won't be able to get that much because that magnitude of harm was just way out of what people would foresee for that small kind of an accident. And so when you have a small event and the harm is way out of line with reasonable people would expect, you just can't collect it. It's considered not foreseeable. Well, here, if you had $1 million worth of data on a $1,000 computer and you damage the computer, but now the person wants $1 million worth of data, that simply is not foreseeable. You couldn't collect that much. In fact, you'd argue that the people who have that much data on this computer ought to have some backup since it's that valuable. And that they're at least contributory negligent for not even having backup. So in any event, in our case, the amount of data on Peter's computers you probably can recover in this case, because it doesn't say that Peter's got that there's $1 million worth of loss there. What it says is it took the employees a couple of weeks or so. They were late for 2 weeks, they were off, and the employees restored the data in a couple of weeks. Well, a couple of weeks' work isn't like, millions of dollars worth of data. So the amount of data loss is probably foreseeable. You should give a discussion about it. Probably foreseeable, and therefore Dan should be able to recover that. So it's a question of whether or not the amount of data loss was foreseeable, and that's going to depend on how much it was. Again, if you lose $10 million worth of data under these unexpected circumstances, you're not going to get that back. But it wasn't that much. It was a couple of weeks worth of work. So you probably get that causation. Damages. Remember that the damages, to collect damages, they must be actual and proximately caused by the defendant's wrongdoing. We got that. But the damages also must not be too speculative. This is not too speculative. Now here on the board I put not speculative, and the only reason I put not speculative here on the board is I don't have enough room. I mean, everything is speculative to some extent. So what I really mean is not too speculative. Be sure to put that "too" in your notes. Not too speculative, okay? Here, I'll put it on the board because somebody will forget it if I don't. And it's right here, not too speculative. Now, so the damages must be not too speculative, and then there's a duty to mitigate. And I don't know anything that Dan could do except to try to recover the data. So Dan wants over here, Dan wants computer repair. We went through that. Dan wants the compensation for the loss of data. we brought that one over to this other. In the loss of data, we've analyzed the right to recover for the loss of data. We have the causation, actual and proximate cause. The damage is not too speculative, duty to mitigate. The additional damage that Peter wants is his loss of income. And his loss of income, again, has to be caused by the loss, by the negligence of Dan, and it was. So we have the but for, that is the actual cause. By that I mean, but for Dan's negligence, Peter would not have lost his income. And then the proximate cause, the loss of income is not too remote. Peter's loss of income is not so remote that you can't recover it. So we have proximate causation also. And finally, the damages, in addition to them being actual and proximately caused, the loss of income must be not too speculative. And right here is where you put in the 10 years. The business has been around for 10 years, so they have good records of the income. So this is where you put the 10-year in there. And there's a duty to mitigate. And anything which Peter could have done to minimize his loss of income, he has a duty to do that. And if there's something that was within reason that Peter did not do, Peter will not be able to recover for the damages which he could have mitigated with reasonable efforts. So that's a loss of income. And finally, Peter wants to recover for the loss of goodwill. And here, again, the loss of goodwill has to be caused. And the loss of goodwill was actually and proximately caused by Dan's negligence. So loss of goodwill was caused to get the actual and proximate cause. The actual being but for, and the proximate cause saying that the loss of goodwill is not so remote from what Dan did as that Dan's liability would be terminated. It's not that unforeseeable. And finally, the damages, this loss of goodwill must be not too speculative, and the duty to mitigate. On the issue of the loss of goodwill being not too speculative, right here we have a problem because goodwill obviously is difficult to quantify, and so this loss of goodwill right here, this loss of goodwill must be not too speculative. And here you point out that goodwill is hard to measure, it may be too speculative to place a value on it, and Peter might not be able to recover this. Now, that takes care of Peter's damages against Dan based on a negligence theory. But you recall that we had some other theories up here. Here they are right here, sorry. The theories, we started out with 3 theories. Negligence, and we've been through the negligence analysis. Here it is on the board. Duty, breach, and for each of the damages that he wants to recover, we have causation and damages, 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 for each of the damages he wants to recover. So we've done that for negligence right here. But next, they ask you what theories you might try strict liability theory. Trouble is that I don't think this will work, because I don't believe that the distribution of electrical power is an inherently dangerous activity. It may be inherently dangerous to the people on the poles who might get electrocuted if they're not careful. But we're talking about, is it inherently dangerous to the people in Peter's position, people who use the electrical power? And the answer is no. I mean, it can be made safe by the exercise of due care, and you can go through the six components, 6 factors that you use to try to establish that something is inherently dangerous if you want to. But I wouldn't even go through the 6 factors here unless I had time, because we all know that the use of electricity can be made safe by the exercise of due care, because we do it all the time. So I would discuss the strict liability and say you can't bring it. Trespass to land is the 3rd theory, and again, I don't think that theory is going to work. This is the kind of situation where you got to understand the kind of intent that is required for trespass to land. When you trespass on someone's land, the intent that is required is the intent to physically be present on that person's land. Okay? You may think it's your land and it's not. That doesn't matter if you intended to be at that location. Then you can bring trespass to land against a person who either intended to be there or intended to put something there on the land, because it invades the person's right to exclusive occupancy of the land. However, if you're driving your car along the road and the tire blows out through negligence or something, and through negligence you end up on somebody's property, okay, they can sue you for negligence, but you didn't intend to put yourself on that property. And so you do not have trespass to land, even though you're on the land. They sue you for negligence and recover whatever damages that you caused to the land, but it's not a trespass to land, it's negligence. For it to be trespass, you got to intend to put the body or the object there. Now, this brings up these funny cases where if you do something off the land, like cut a power line or put water into the drainage pipes or something of that sort, like is that, when it's done off the land and it causes some effect on the land, is that going to be treated as a trespass to the land or not? And the rule is kind of fuzzy. The rule seems to be this. Prosser says, if what you did invariably is going to cause the trespass on the land, you connect a water pipe off the land and turn it on, and the water is going to run through a pipe and onto the land and do some damage on the land, well, there you put the water into a pipe off the land, it invariably is going to end up on the land. So that would be just as though you went there and put the water there. But when you look at things where the person acted in such a way that maybe you'll end up on the land, maybe you won't, negligent driving, for example, then the process says, no, you got to intend to be there, or do something that invariably is going to put you there or put some object there on the land. Well, in this case, what happened is that Dan put some electrical current into the wire. And is this electrical current invariably going to end up in Peter's place? Well, I don't know. Surges can go all kinds of places, and so it's not quite the same thing. And generally speaking, the courts are not going to treat this under trespass to land. So you probably don't have trespass to land because the lack of intent to put something on that land. What Dan did resulted in something going on the land, but he didn't intend to put something there, and it wasn't inevitable that it would end up there. So you probably don't have trespass to land. But one other cause of action you might think of is nuisance. Nuisance is the non-trespass or interference with the quiet use and enjoyment of the land of another. But remember, nuisance is not a cause of action. Nuisance is a kind of injury, a type of injury, not a cause of action. It's a kind of injury where if you're on your land, suddenly you cannot use and enjoy your land because there are loud noises or smoke or bad smells or something coming onto the land, so you cannot enjoy the use of the land. And it's a non-trespassory invasion because the smells and the bad smoke and that sort of thing isn't treated as a trespass, not like an object that came onto your land, even though we know the atomic theory of matter nowadays. So these non-trespassory invasions can cause whatever damage they cause, one can recover, and this non-trespassory invasion of this non-trespassory stuff gases, fumes, bad smells, flashing lights, loud noises, that sort of thing. And in our case, electrical current coming down the wire. If that's not going to be treated as a trespass, then it could be treated as a non-trespassory invasion of a right to occupy. But I don't know that the electrons are ever going to be treated as occupying the land. So I really don't think this would be treated as a nuisance problem. It's just it'd be an awful stretch. So I think the issues you needed to raise were negligence, Peter against Dan for negligence, strict liability won't work, trespass to land probably will not work. Next, just a couple more things now. Peter wants punitive damages from Dan, and in order for Peter to get punitive damages, you know that you don't get punitive damages for ordinary negligence. And if Dan was just ordinarily negligent, Peter will not get punitive damages. On the other hand, if what Dan did can be viewed as reckless, okay, then Peter is entitled to punitive damages. And so you give some kind of definition of reckless and say maybe maybe Dan was negligent, was reckless. In that case, Peter can get punitive damages. Finally, the people who were laid off, the employees who were laid off for a couple of weeks, want to get paid for their lost wages. And the answer to that is no. They are simply one step too far removed in the chain of causation. You see that's this point gets tested a lot. I can think of 4 or 5 examples immediately where the bar has tested this concept. Let me run through it for you very quickly. If here in San Francisco, a few years ago, there was a case where a person who worked for the electrical power company dropped a wrench into the transformer, and a large part of downtown San Francisco was without electrical power for the rest of the day. Now, if that happened, say, in the middle of the day, thousands of people, maybe 50,000 people, had to leave their offices and go home because there was no electricity downtown due to the negligence of this electrician who dropped the wrench. So the electrical power company, called PG&E here, PG&E was negligent because its employee was negligent. So are all 50,000 of these people going to be allowed to sue PG&E for half a day's work? I mean, after all, PG&E was negligent, and there's no question that the negligence of PG&E caused these people to lose a half a day's work. They were ready, able, and willing to go to work, and they couldn't do it because of PG&E. And so, are you going to let all 50,000 people sue PG&E? And the answer is no. It's simply impractical for obvious reasons. You would flood the court with too many lawsuits, these small-time lawsuits. It's not a practical way to run the society. And so what we say is that this harm, that it's true that if we lose electrical power, these people can't come, that the people we supply to won't have power, then the folks can't come to work. Well, the folks who can't come to work, they will lose something, and those people who can't come to work will not be able to collect. Even though they've lost something, we'll say you're just one step too far removed. Now, so the laid off employees will not be able to recover. Some other examples of that, one example of that happened where a plumber, in the February 1991 question, where a plumber, I think I covered this in one of my lectures, the plumber had done some negligent plumbing, and a few years later the pipes broke open and caused all kinds of damage in the swimming suit store where the pipes were, and one of the employees there named Emma was laid off while the place was being repaired. She was one step too far removed, not viewed as being what the plumber did was not the proximate cause of her loss of wages. It's one step too far removed. It's not the count of the steps, it's the public policy that's involved. If you allowed that, the suits would get out of control. Another place where this was tested in the question, the February 2007 bar. There's a question where a a diamond cutter was on his way to do a big diamond cut job, and someone negligently killed the diamond cutter, and the person who owned the diamond, this was probably the only cutter in the world who could cut it, and the person who owned the diamond sued the driver for negligence. Says, driver, you negligently killed this one diamond cutter that could cut my diamond, and I want my losses. Well, that's an negligent interference with a contract, and it's just one step too far removed, and you cannot collect it. And that's what would happen here to the laid-off employees. That is the end of the analysis of this question.